In this video, I'm going to run through 10 possible ways of challenging a private parking charge notice. Not to be confused with a penalty charge notice. This is a fine and can only be issued with lawful authority, usually by a local authority. So a parking charge notice is a private invoice from a private parking company, albeit usually issued if they believe that you have contravened or broken their terms of contract for parking on private land. And make sure you stick around till the end of the video because I'm going to explain how I would deal with such things if you plan to challenge it. But first of all, if you're new to my channel, I'm a barrister who helps you understand law. So make sure you hit that subscribe button and the bell icon so you get notified of new videos. And you can also leave your questions down below. They might find their way into a new video or over at Black Belt Secrets where I answer questions from the comments. So I'm going to start this video by saying this guidance is for when there is a genuine reason to challenge one of these parking charge notices. If the charge has been issued genuinely under fair terms, then of course you should be paying it. But in many cases, there are several reasons you may be able to fairly challenge it. So here goes. In at number 10, a rather strange one, is where the parking company was not in fact in charge of the car park at the material time. This might be where there's been a changeover of companies that are responsible for the car park, but if the second company has issued you the parking charge notice, this may well be a reason to challenge the ticket, because it is arguable that they could not have known whether you were really in contravention of the agreement for parking on that land. In at number 9 is the scenario where you didn't own the car at the material time that the ticket was issued. This might well be the case where you've recently purchased the vehicle, and so at the time that the ticket was issued, you didn't own it, so you were neither the driver nor the registered keeper of the vehicle, and this is another basis upon which you can challenge the validity of a ticket. A slight variation of this might be if your vehicle was stolen and the thief parked it on private land. This is another ground upon which you can challenge the ticket. In at number 8 is if the parking ticket itself is invalid. This might be because the date or the time were completely wrong, or more likely if the registration number of the vehicle is wrong. Quite obviously, if those details don't match up, then this is another area you can challenge. In at number 7, you might challenge the ticket if the parking company is not a member of an accredited trade association. More about this a bit later. For number 6, it's possible that when you made a payment, you put in the wrong vehicle registration. But if you can show that you have actually made a payment, then again, this is another way you can challenge the ticket. Although there might be some administrative costs involved in clearing it off the system, you can still show that you've made the payment and the higher amount of fine is quite likely no longer enforceable. For number 5, I have the scenario where there are very often grace periods written onto the sign, or even a grace period which would be fair in all the circumstances. If you've pulled onto the car park and realised it's not close enough for where you need to be, and there's either a grace period on the sign or you've simply left immediately, this could be another way you could challenge the ticket. In my view, even if this found its way all the way to court and you literally drove onto the car park and left immediately, I think it would be quite draconian for a court to enforce a full fine simply because you entered the car park in error. At number 4, there may be some genuine mitigating circumstances. Mitigating circumstances are something that we often discuss in court. They mean something that brings down the seriousness of what happened. For example, if your vehicle had broken down and you simply had no choice because you simply couldn't leave the car park, this would be a mitigating circumstance. Similarly, if you'd parked at a car park and then you were taken ill and taken to hospital and perhaps it was several days before you could come back to the car, this would be a challenge on a basis of ill health, which again in my view would be a reasonable ground to challenge such a ticket. At number 3, coming to scenarios which are fairly common these days, is when the parking machine itself was just simply not working. Many of them I've known now are moving to apps and technology rather than coins and payment cards, and sometimes the apps just simply don't work. If there are no machines available and there's no other means of making a payment, but you get a ticket before you have the opportunity to make a reasonable payment at a later date, then again, this is another way you could challenge the ticket, because you could quite reasonably make representations that you had the intention to pay, but you simply couldn't do so because the machines were not working. In at number 2 is where the charge is disproportionately high and therefore unreasonable. But a hint of caution comes with this one because of the Beavis case in 2015, where the Supreme Court said that £85 was not an unreasonable charge. So if the charge is in this remit, then this alone is not going to be a basis to challenge the ticket. However, if you got a ticket that was £300 or £400, this might well be a different issue. And again, you might be able to challenge this in court. And remembering, of course, that there have been other cases against Parking Eye, which was in the 2015 case, where parking charges have been successfully challenged for being unfair. I'm referring to Nicholas Bowen QC, which I discussed in my previous video. And my number one reason for challenging a parking ticket is that the contravention itself simply didn't happen. And this could be for a number of reasons. Firstly, perhaps you simply weren't there and you can demonstrate that you and your vehicle were, in fact, somewhere else. Of course, this is a matter of evidence, but if you can prove and show that, then of course this will support a robust challenge if you are ever taken to court. But even in the case where you were there, but the signs were very misleading, they told you one thing and then the parking charge told you that the charge was issued for another reason, which contradicted the information on the signs, so long as you can show what the signs were saying at the material time, then there was no contravention because you were accepting the terms written on the sign, not the terms that were alleged in the parking notice. This may also be the case if the terms were unclear or the sign itself was unclear. Let's say it was faded, covered by trees, covered by snow, and all these kinds of things. Or perhaps the ticket that you are issued says that you were over the line in the parking bay. But in fact, there were no visible lines or the lines were unclear, so it wasn't clear to you that you were parking outside of the parking bay. This might be another reason that the contravention itself simply didn't happen, because it would be unfair for a contravention to occur if you in fact couldn't see these lines and therefore couldn't comply even if you wanted to. And then of course there is the scenario where you have paid for the ticket, but the machine didn't dispense the ticket. I've certainly had this happen to me. My money has gone into the machine, but the machine didn't issue me a ticket. Now, whilst this is going to be very difficult to prove if you've simply used coins, but if you've used a contactless card, and most banking apps these days will show you that there's a pending transaction almost immediately, then it shows that you've got a pending transaction for the money that you've paid to the machine, even if the machine hasn't given you a ticket. In fact, this very scenario happened to me once and I took photographs of everything, the machine, the signage, and then just to be robust, and me, being robust and thorough, I wrote an email to the parking company to explain the situation that we had paid, not received a ticket, but in the event that they were going to issue me a ticket, I would certainly vehemently defend it because the machine took my money, didn't give me a ticket, and therefore no contravention in fact occurred. But this brings me very nicely onto how to actually challenge these tickets if you plan to do so. The first and most important thing to say is that evidence is everything. If you unfortunately end up in court, because that's the only way these parking companies can in fact force you to pay by taking you to court and getting a judgment, the court is going to want to see every shred of evidence that you have that supports the reasons why you shouldn't be paying this parking charge notice. These days, the easiest form of evidence to gather is photographs. This will be of everything, whether you think it is relevant or not, because it may well be relevant later. If it were me, I would do a walkthrough in the car park right from the entry, taking photographs of the entry signs, what the car park looks like from the outside, any signs that are visible or not so visible as the case might be, any machines that are available, how they are accepting payments, if the machine is not working, perhaps any error messages on the screen. If the markings on the floor are unclear, I would take photographs of those. Or even in a possible scenario where your car's been blocked in by another car and you simply can't leave and you end up with a ticket, I would take a photograph of that, of course, if it's there when you come back. But in addition to this, many things that you may not think about, if there are lots of other people around having the same problem with the meter, take some details and stay in touch with said person, because they can provide a witness statement to the fact that this machine wasn't working, the lines were unclear, the signs were unclear, and so on. In the event that you've been taken ill and perhaps taken to hospital, you will require evidence of this as well. Or in the case if your car was stolen, obviously report it to the police. You will receive a crime reference number which will prove that your car had been stolen. And the second most important thing to say about challenging one of these parking charge notices is absolutely do not just simply ignore it. I can understand why lots of people don't want to acknowledge it or deal with it, simply screw it up and put it in the bin. Whilst in many cases it may simply go away, in many other cases it will not, and you may well end up in court, in which case you will be paying the court issue fees and any hearing fees if you've gone all the way to a court hearing. In some circumstances, the parking company may even apply for summary judgment. Summary judgment is where the court makes a ruling without a formal hearing. If you've simply refused to gather and provide any evidence to the contrary of the parking company's claim, then they may well get summary judgment, and that may well be before the claim is issued to the small claims track. And in this scenario, there's the very real risk that you may get costs awarded against you, even though the claim would otherwise be allocated to the small claims track. So the first thing I would do is look up the parking company and see whether they have a normal appeals process. And together with all of the evidence that you've gathered, I would write a robust letter setting out the reasons that you dispute the ticket and see what they say. Failing this, you can check whether the parking company is a member of one of the accredited trade associations, such as the British Parking Association or the International Parking Community. Each of them have their own timeframes within which you can submit an appeal to them as a third party, which as I understand it are 28 days and 21 days respectively for each of those. But ultimately, failing all of that, if your appeals are rejected, the final resort for the parking company to actually get the money from you is in fact to take you to court. Many of them might even threaten you with debt collectors and warn you that it's going to damage your credit rating, but none of this is going to happen unless they actually take you to court, get a judgment, and then you still don't pay it. And in fact, there are going to be new rules that deal with all of these practices, so make sure you subscribe because I will be doing follow-up videos when those new rules are drafted and are in force. And just as a reminder, once again, this is about parking charge notices, which are private invoices. They are not a fine, which is known as a penalty charge notice. So again, the very first thing you do is check which one of those you have, because they are very different. So give this video a thumbs up if you found it useful, and remember, stay humble and subscribe.